forward from all the remaining counts. And essentially to have two separate trials. And our position, Judge, is that to try all these together, especially the multiple counts of filing false report, essentially gives the jury the option in their processing to say, well, she's guilty of these crimes, the false reports, so therefore she must be guilty of the felony murder, the aggravated child abuse, and aggravated child neglect, without evaluating the elements of each of those offenses. And so we are asking the court to sever those counts. In the state's response, on page 5 of that, they make the statement that at the core, the false reports prove the murder. And I think that is the whole problem here, Judge. If the state wants to present evidence,
so we're here monitoring the Megan Boswell case. For those that don't know who Megan Boswell is, she's a girl that she is going to trial right now over her child. And let's see if we can bring some stuff up here. And she's charged in the death of her 15-month-old son, Ethan.
That's different than saying than the state presenting the evidence of those false reports in the charge of the felony murder case.
Yes, she was also in Tennessee shortly, well, not really shortly after summer, but in and around the time. Is it a daughter? I thought it was Ethan.
If the jury evaluates that,
her daughter, yes, Evelyn.
There is sufficient evidence,
right,
not a reasonable doubt, to prove the elements.
Evelyn.
What it is. But it's not appropriate if they say she is guilty of filing a false report. Don't even look at the elements of the other cases and convict her based on that. That's what we're trying to avoid by this motion, Your Honor, is to take that possibility away from the jury. If they can say.
Exactly. It is hard to keep track of all of them.
Therefore,
that's Ethan Boswell. Yes, thank you for the correction. Yeah.
I think that, the state's response
Boswell
pretty much points that out.
Ethan is the father. Thank you.
The situation. So that's why we're asking for a severance of those.
Judge, the state's following our response to Mr. Sproul's motion. I believe under the case law, the state required for some evidence for this court to.
Before you got too far into
it. Yes, so I'm not really going to respond to Mr. Sproul's arguments yet. The state would, at this point, I'd like to go ahead and put on evidence in regards to the sentence.
This is the case. I misspoke and was speaking about Ethan, the father. This is related to Evelyn Boswell, a 15-month-old girl that was killed at the hands of her mother. If this is the right case that I'm thinking about, it was the grandfather that called this in.
Good morning.
Good morning.
You are Special Agent David Gratz, is that correct?
That's correct.
And who are you currently employed with?
The Tennessee Bureau of Investigation.
And what is your position or assignment there with the TV?
They're alleging Miss Robin. Yes, she was.
Criminal Investigation Division.
And
reported her child missing.
About 2.5 years.
What did you do before you joined the TV?
I was an assistant district attorney for about 5 years.
Where were you in ABS?
In the 3rd Judicial District.
how long did you do that?
About 5
Have a great day, Anissa.
Agent Gratz, if we could, I want to go back to February of 2020. Were you called out to
Lisa, thank you. I rewinded it so we could get it closer to the beginning.
an investigation that involved a 15-month-old child by the name of Evelyn Boswell?
Yes, I was.
And at that time, the kind of the initial report that got everything started really wasn't a call to law enforcement. Initially, it was a call to the Department of Children's Services that was made on February the 18th. Is that correct?
Yes.
All right. And who was it that made that initial call?
It was actually the child's of Evelyn's paternal grandfather, Tommy Boswell, and also his mother, Mary Boswell.
All right. And let's kind of set the stage here a little bit by identifying some of the parties. You mentioned the biological grandfather who made the call. That's Tommy Boswell, correct?
Yes,
And what is his relation to the defendant, Megan Boswell?
that's her father.
And then the child, that is Evelyn Boswell, correct?
Yes.
What was the, without getting into too many of the facts, what was the nature of that initial call to DCS?
It was essentially two-pronged. Number one, they hadn't seen the child in quite some time. There was also sort of a rumor or a belief that the child may have a broken arm.
So, as you mentioned, there was a possibility of potential injury to the child. So the sheriff's office had gone along to assist DCS because of the possibility there might be some potential child abuse there. Is that right?
Yes.
When the sheriff's office and DCS got there to investigate, was Evelyn present so that they could evaluate to see the child, see whether she had any injuries?
No.
What was the explanation or, I guess, the story that was given by Megan Boswell at that time as to where her child was?
Megan stated the child Evelyn was with her father, who she stated was Ethan Perry.
And did she say where Mr. Perry was at that time?
She, if I remember correctly, she sort of speculated that he might have been in Louisiana, but he also might be living in Kingsport.
Were you all able to locate Mr. Perry?
Not at the time, no.
Through further investigation, did you find out where Mr. Perry was?
Yes,
Okay, and where was he?
he was active duty military stationed in Louisiana.
And did you all make contact with the folks down in Louisiana?
Yes,
And was Mr. Perry, in fact, at that Army base?
yes,
Was Evelyn there with him?
no,
So you all were able to pretty quickly prove that the information that Ms. Boswell had given you about the location of the child was not correct. Is that right?
yes.
Now, after that initial report, over the next few days, did you, along with other investigators and officers, conduct a series of interviews with the defendant, Megan Boswell?
Yes.
All right. And what were the nature of those interviews? What were y'all talking about?
We were trying to locate Evelyn Boswell.
And after speaking with her, and you spoke with her on multiple occasions, would that be correct?
Yes.
All right. What did you determine about the information that Megan was giving you?
It was false.
And as a result of that, on February 25th of 2020, the Sullivan County Sheriff's Office charged Megan Boswell with one count of false report. Is that correct?
Yes.
And that was for the information that she gave to them initially back on February the 18th of 2020. Is that right?
That's correct.
All right. Agent Kratz, if you could, I'm going to hand you a document and ask if you can identify it. Do you recognize what's been handed to you?
Yes.
And so,
It's
what is it?
it's a certified copy of the general session.
Okay, was that the affidavit of complaint that was filed on February 25th, 2020, charging Megan Boswell with that one count of false report?
Yes.
Judge, we would make that exhibit one of this hearing.
No objection.
Right now, we're watching a court hearing of Megan Boswell. She reported falsely of her daughter missing. Her father, Evelyn's grandfather, is the one that reported her missing.
Correct. This
And the body of Evelyn Boswell was found in a tote on location at the grandfather's property.
Is that right?
That's correct.
Because of the fact that at that point in time, on February 25th, you still didn't know where Evelyn was.
That's correct.
But your investigation did not end on February 25th.
No.
All right. In fact, there were, just tell the court, I mean, besides the TBI, what other agencies were investigating Megan's disappearance, or Evelyn's disappearance, sorry?
The initial investigating agencies would have been DCS and Sullivan County Sheriff's Office. Later in the evening on February the 18th, Special Agent Brian Pritchard was called in to assist Sullivan County Sheriff's Office. I was called in the next day to assist. And by the time I arrived, around noon, I believe on the 19th, the Sheriff's Office, TBI, the Federal Bureau of Investigation, was also present.
And in addition, your investigation, you all were interviewing witnesses.
Yes.
Is that right? You all wrote search warrants for social media accounts.
Yes.
Is that right? You all, as part of your investigation, collected numerous cell phones, items of digital evidence that had to be reviewed, correct?
Yes.
All right. And what kind of volume are we talking about here? I mean, how much evidence were you all looking for?
If I remember closely, or excuse me, correctly, it was close to a terabyte of everything we collected.
And your investigation continued up in time, and then on March the 6th, 2020, something happened, correct?
Yes.
And what was it that occurred on March the 6th?
We discovered the remains of Evelyn Boswell.
All right. And where were those located?
At Tommy Boswell's property on Muddy Creek Road.
Tommy Boswell is the grandfather.
At a location that you all, based on your investigation, were able to tie specifically to the defendant, Megan Boswell.
Absolutely. The property itself is where the defendant used to live.
And was there anything of significance about the exact location that the body was found?
Yes.
Okay, what was that?
We found the remains inside of the building that was referred to by the family as the Playhouse. It was out behind what I would call a storage building on the property. And this Playhouse was built by defendant Megan's grandfather as a playhouse for her when she was a child.
Now, after you all located the body, it was sent for an autopsy, is that right?
Yes.
Did you all collect other evidence there at the scene?
Yes.
And there, as a result of collecting that evidence, it was sent off to have forensic examination done, is that right?
Yes.
Performing all that testing takes a pretty good period of time, is that right?
Yes.
All right. And while all that was going on, you then presented to the grand jury and a presentment charging Megan Boswell with 11 counts of false report. Is that right?
Yes.
And that was done on May the 20th of 2020.
Yes.
Correct. And Agent Gratz, I'm going to hand you another document asking if you can identify what you handed to you.
Pay close attention to the steps they're taking in these cases to build the case. This is going to be important with Summer Wells.
Yes.
You ready to ask that?
Yes, it's a certified copy of the presentment from May the 20th of 2020.
Judge, at this time, we would need to make that exhibit 2 to this hearing.
Judge, we don't object, that's in the court file. Me too.
Agent Graff, once the, I guess it was several months later, you got the final autopsy report. Is that correct?
Yes.
And
They are. I don't think they said they moved it yet.
results of the forensic testing that was done at the TBI lab.
Yes.
All right. And after that was completed, did you then re-present this matter to the Sullivan County Grand Jury?
Yes,
And that was done on August the 19th of 2020, is that right?
that's correct.
And this time I'm going to hand you another document after you have identified that.
Yes, it's the certified copy of the presentment from August 19th.
All right. Judge, could I would move to make that exhibit number 3 to this hearing?
I've noted.
Agent Gratz, that superseding presentment, that is the presentment that charges 2 counts of felony murder, the aggravated child abuse, aggravated child neglect, tampering with evidence, 12 counts of false report, abuse of the courts, and failure to report death under suspicious circumstances. Is that right?
Yes.
Now, based on your investigation, which by the time August rolls around, have been going on for several months, correct?
Correct.
Were you able to determine when the defendant had begun telling this false information about where the victim was located?
Yes.
And what did you determine about that?
Based on everything we've collected, the first, I guess, time we found the defendant told the story that Evelyn was with Ethan was during the first week of December of 2019.
And what sorts of things told you this? What was the evidence you were looking at that gave you the clues you was?
Text messages, witness statements.
And so this was happening back in December of 2019.
Yes.
So this was several months before law enforcement ever even got involved.
That's correct.
Correct. If we could, Agent Gratz, I'm gonna, could we pass exhibit number 3 back to you? What I'd like to do, if you could turn to count 6, which is the first false report count. What I'd like to do is kind of go through those and talk about the dates that they were made, who they were made to, and what the substance of that false report was. So we can kind of get that on the record. We'll start with count 6. That was made on February the 18th of 2020. Statement made to Detective Tracy Perez with the Sullivan County Sheriff's Office. What was the false report related to that?
It was when the defendant, Megan Boswell, claimed that Evelyn was with Ethan Perry.
So it was a false statement relating to who had custody of the child.
Yes.
Okay. Now, if we could, count 7, again, on February the 18th of 2020, a statement made to Detectives Michelle Gillum and Tracy Perez, both with the Sullivan County Sheriff's Office. What was the false statement related to that case?
I believe this was later in the day or evening on the 18th, and this was concerning the lack of knowledge of the whereabouts of Evelyn and the efforts that the defendant had taken to locate Evelyn.
So that would relate to false report of where the child was, correct?
Right.
Count 8, again on February the 18th of 2020, false statement report to Steve Williams, detective with the Sullivan County Sheriff's Office. And what was the nature of that false report?
This was the statement where the defendant discussed Ethan Perry refusing to return text messages and voicemails regarding Evelyn.
So again, that's a false report regarding someone else having custody of Evelyn, correct?
Yes.
Count 9, another false report made on February 18th of 2020 to Captain Joey Strickler with the Sullivan County Sheriff's Office. What was the nature of that?
This was about the last physical contact she had with Evelyn and the lack of knowledge of the whereabouts of Evelyn.
So that one deals with more of the time frame when she last had contact with the child, correct?
Yes.
Count 10, a report made on February the 19th to agents with the FBI, Jeff Lamb and Todd Wilcox. What was the nature of that?
This was her discussing her being Megan Boswell, the time frame in which she stated she gave Evelyn to Ethan Perry.
All right. Count 11, report made on February the 20th of 2020. Again, Captain Strickler with the Sullivan County Sheriff's Office. What was the nature of that report?
This is when the defendant stated when she last saw Evelyn was with Ethan Perry on December the 26th of 2019, and she had not contacted law enforcement on the advice of Angela.
All right, so Angela Boswell, just clear on the record, that is Megan Boswell's mother, correct?
Yes.
So this report has to deal with two things. One, the time frame in which she claims she last saw the child, as well as implicating someone else in disappearance and the fact that they did not locate the child, correct?
Yes.
Count 12, another report made on February the 20th of 2020, to you as well as Detective Matt Price with the Sullivan County Sheriff's Office. What was the nature of that false report?
This was when the defendant stated her mother, Angela Boswell, had Evelyn Boswell.
And so again, she's implicated someone else in the disappearance of her child. Correct?
Yes.
Count 13, again on February the 20th of 2020, report made to yourself as well as Detective Matt Price. What was the nature of that report?
This is when she stated that her mother, Angela Boswell, had Evelyn since mid-December, and that Angela refused to tell the defendant her location, Evelyn's location, and she didn't call the police because she was afraid, the defendant was afraid that Angela would harm Evelyn.
So again, she's given false information about the time frame in which she last saw the child, as well as implicated someone else having custody. Correct. Count 14, again on February 20th of 2020, statement made to you as well as Detective Matt Price. What was the nature of that false report?
This is when the defendant said her mother, Angela, had taken Evelyn and wouldn't return Evelyn to the defendant because she owed her money and would not return Evelyn until the money was paid.
Count 15, statement made the next day on February the 21st of 2020. That statement being made to you as well as Detective Matt Price. What was the nature of that false report?
This was her discussing that, again, Angela had Evelyn at an unknown location, and the defendant had attempted to locate Evelyn, but she did not know where she was and didn't have any additional information.
last two, count 16, false report made on February the 23rd of 2020. Statements being made to Agent Chris Willpoy was a TBI. What's the nature of that false report?
This is when the defendant said that, again, Angela had Evelyn Boswell and had given Evelyn to an unknown or unnamed person, and that Evelyn was safe and would have a better life with this unknown person.
So this is yet another account where she is implicated someone else having custody of the child.
Yes.
And finally, count 17, false report made on February the 25th of 2020 to Detectives Jonathan Licklider, Robbie Clemens, as well as Agent Brian Bradley with TBI. What was the nature of that false report?
This is when she did say she was aware that Evelyn was dead. However, she told the story that it resulted from either her or Hunter Wood rolling over the child while sleeping, but she did not know the location of Evelyn's body.
So she blamed the ex,
Her attempt to
Ethan, and her mother, Angela.
Yes. The fact that she was responsible for the child.
Yes.
So these false reports kind of cover a number of topics. She implicates others in the disappearance. She gave you all false information about who had the child, about where the child was. Is that right?
Yes.
And ultimately, she blames someone else for the child's death. Is that right?
Yes.
You had mentioned earlier a number of these false reports relate to giving information about the child being with Ethan Perry. Is that right?
Yes.
Did you see evidence during your investigation of her telling this false report or false information to other individuals?
Yes.
And where did you see that?
Text messages or Facebook messages, as well as witness statements.
And who were the people that she was telling this to?
The first statement we located was to an individual named Haley Sparrow, I believe.
Was this a friend, someone?
Believe
It's
they were-
almost a friend of Megan's.
I believe they were classmates in school.
Did she make this statement to any family members? And who?
Yes, it was the story she was telling to her family about why Evelyn was not present.
So the false information that she was telling you all in February, when you're doing this investigation, this was same false information that she'd been telling family and friends for several months, correct?
That's correct.
And again, this information that you're getting in the investigation, it's based upon your interviews with the defendant, Megan Boswell, right?
Yes.
So you're getting all of your information directly from her.
Yes.
And you mentioned this evidence.
I want you guys to pay attention. They monitored her Facebook page. They found inconsistent statements in obviously social media. She's blaming multiple people, her ex, her mother. She's saying it's over money. At some point, she says she knew she was gone, but didn't know where she was. I want you guys to pay attention to the processes associated with this case. This could be very helpful to us in the Summer Wells case and what they are doing behind the scenes in the Summer Wells case as well.
That you all found on your review of the social media and the digital evidence. When did that begin? Were you able to figure out a time frame that she began to tell this false information to her friends?
Yes, around the first week of December 2019.
All right. And I know we've got a copy of the presentment into evidence. The offense date for when you believe that the child was murdered, that was early December of 2019, correct?
Yes.
So this would have been about the same time period that the child was killed. Is that right?
Yes.
Now, you mentioned that you reviewed the social media evidence. In going through this, she had family and friends that she was talking to somewhat regularly during this time period, right?
Yes.
Was there discussion, talk about Evelyn at that time?
There was.
And despite all that, no one, none of her family, none of her friends made a report that Evelyn was missing or they had concerns about her until that February 18th date. Is that right?
That is correct.
Do you know why that was?
I won't object to
I'll
speculation.
start. Let me ask you this, Agent. After you reviewed this material, these text messages, social media posts, as well as the interviews that you conducted with various witnesses, did you reach a conclusion about how long the defendant had been telling this false information?
Yes, since around the first week of December.
And again, that was along the same lines as the time in which the child was last seen alive and believed the child was murdered. Is that
Yes. Yes.
right? And because you kind of went through your investigation and learned that the information that she told you, as well as the information she was telling her family and friends, was not true. Did you reach a conclusion about who was responsible for the child's death?
Yes.
And who was that?
The defendant, Megan Boswell.
Based on your training and experience as an investigator with TBI, did there appear to be common threads in regards to these false reports?
Yes.
What was that?
They seem to deflect attention or suspicion away from the defendant, Megan Boswell.
And again, all these false reports, all this information was coming from the defendant, Megan Boswell, correct?
Yes.
That's all the questions that I have this time.
Before you start this, in the motion.
Guys, this is for the change of venue hearing as we're listening to this.
Judge, I interject. I mean, essentially our motion focuses on false reports. The general is addressed. So basically, the motion for report. The oral amendment, I would say, the motion for report is that you're asking for counts 6 through 17. He said, those are the counts we have the concern with, Judge. General is put on the proper.
Agent Grant, if you would answer the questions that Mr. Schwartz has for you.
Judge, I don't have any questions. I'm taking Grass's testimony as offered essentially a proffer, so the court can make a determination on this. So we're not going to cross examine. Any other proof?
No, I approve the extent, Judge.
Yeah. I think so.
Judge, as set forth in the response that was filed to the defendant's motion, there's a 3-part test that the state has to meet after the defense objects and moves to sever under Rule 14. The first part of that is to show that these offenses are part of a common scheme of plan. And the state would allege and assert that basically the plan.
Lori, yes, she is.
Part one was a plan by the defendant to prevent the discovery of the victim's body. And then secondly, to escape prosecution for the abuse and the murder of her child. You've heard evidence and testimony here today from Agent Gratz that the defendant began spreading this misinformation, began telling false reports to everyone, family, friends, anyone who would ask, about where Evelyn was at or near the time of when this murder was committed, which was back in December of 2019, which would have been 2.5 months before law enforcement was ever even involved. He was able to determine this through the witness interviews that they were conducting, the review of the social media accounts, text messages, and it was clear to him what she was doing. And basically what she was doing was trying to deflect attention from the fact that her child was dead. And so she's telling family and friends, custody of the child is with Ethan Perry. My mom has her. My mom told me not to file these reports. And this information was consistent. The information she was telling them, same thing she was telling law enforcement. And she's doing this from December 2019 all the way up to and continuing to this time in February where law enforcement first gets involved. She was giving false information about who had the child, false information about the last time that she'd seen the child live. She's blaming, implicating others in the disappearance of the child. And then ultimately, in the final false report, she implicates someone else in the death of the child. So all this evidence is inextricably intertwined together. And it clearly shows a plan on her part. That plan is to deflect attention away from herself, away from the fact that this child is missing and dead. And then ultimately, it's an attempt to keep law enforcement from being able to charge her and eventually prosecute her. These acts are linked in time, they're linked in place. So we would argue that they are part of this common plan. I think an argument could also be made, Judge, that they're in some ways part of the same transaction. I don't think that's a strong argument, but I think in some ways this was really a continuing transaction that began when she murdered the child and continued up until the time that law enforcement got involved. The second prong, the finding the court has to make, is that the evidence of these false reports is relevant and admissible in the trial of the remaining offenses. Now, case law shows that you can use this type of evidence to show motive, to show intent, to show guilty knowledge, and to show absence of mistake or accident. The fact that the defendant was repeatedly supplying false information to law enforcement when they are investigating the disappearance of her child is clearly relevant to show the defendant's state of mind at that time. It shows her guilty knowledge that goes all the way back from December through February regarding the murder of her child. And again, it goes to these efforts and the intent that she had, which was to divert law enforcement from ever discovering the body in the first place. The third prong that the state has to show is that the probative value of the evidence, of these other evidence, of the other offenses, the false reports, is not outweighed by prejudice. And this is the element that Mr. Sproles addressed with the court initially in his opening comments. And the state would respond this way. The probative value of these reports is extremely high. Obviously, they deal with the facts that Megan Boswell was actively covering up the disappearance and murder of her child for 2.5 months before law enforcement got involved. They show her state of mind. They show the guilty knowledge that she had about it. Now, obviously, a jury being told that she has given false information to law enforcement is not going to reflect well on her character. That is a given. But the crimes themselves, the false reports and the felony murder, aggravated child abuse, aggravated child neglect, abuse of the courts, those crimes are not similar in nature in any way. So there is very low propensity, if they hear evidence that she has lied to the police, there's not a propensity to believe that just because someone lies to the police, they're going to go out and murder their child. There's just no, the two crimes are not similar in nature. So the state would argue that because of that, the probative value is not outweighed by the prejudice in this case. Finally, Judge, if I could, I'm going to pass up a copy of the case, which is State versus LaForce. It's a 2008 case, and I believe this is the case which is most similar to the situation that the court's dealing with here today. And that was a case that the Court of Criminal Appeals held that where you had a common plan or scheme, which was basically a defendant who was trying to escape prosecution for the underlying crime, that could constitute a common scheme of plan. And the facts of that case are actually not as strong as the facts in this case. What happened in that case, the defendant was arrested and charged with prescription fraud. 2 weeks later, at a preliminary hearing, the defendant threatened a witness who had testified against him at the preliminary hearing. So as a result of that, the state charged coercion of a witness and retaliation for past acts. And despite the fact that you had a clear breaking time with these offenses, the court held that the second set of offenses was clearly part of this plan on the part of the defendant to escape prosecution and being convicted of those initial charges for the prescription fraud. We've got a very similar situation here, but the facts in our case are even stronger because we don't have that break. As you heard from Agent Gratz, these after the murder occurred, these false reports and these lies were being told almost instantaneously. So again, you've got all these false reports that are being made by the defendant, and they're for the sole purpose of trying to avoid the body being discovered, the crime being detected, and ultimately her being able to be prosecuted for the abuse and murder of her child. And again, she's been spreading this information almost from the get-go, so we don't have that break in time. Based on that, Judge, it's the state's argument here today that we have met the three prongs that are required under Rule 14 to keep all of these counts consolidated, and the state would ask that you deny the defense motion to sever counts 1 through 4.
Judge, Jim Harper argues that the probative value of this information is high. So is the prejudicial effect. And I would, Agent Gratz's testimony very clearly focused the court's evaluation here on that part of the three-pronged test. And I would urge the court, keep in mind what we're asking for here, Judge. We're not asking to suppress that evidence that Agent Gratz testified in either of the trials. All we're saying is that the false report charges should be severed and tried separately. And as I said early on, the question of whether what we're trying to avoid is a situation where the jury can say she's been found guilty of filing a false report in these counts, so therefore she has to be guilty of the murder. So it doesn't mean they can't present that evidence in both trials. But the prejudicial problem there is the fact that she being tried trial for those false reports as well. And jury we believe, our assertion is that makes the prejudicial effect higher than the probative value of the evidence. And once again, we're not saying they can't present that evidence. We're saying there should be 2 trials.
So you're saying
That's the difference, attorney.
the evidence of false reports is relevant to the murder? You're just saying that prejudice far outweighs. That's our argument. And, just to clarify even more, the evidence of false reports is the state's evidence. So we're not saying they can't present that. We're just saying the false reports should be tried separately.
So it sounds to me like you're trying to separate charges.
We'll take that under advisement.
I haven't seen where they said the cause of death.
To address the issue, we had submitted previously the order for mental evaluation. I don't know if it's been scheduled, I don't know if it's close to some deadlines, so check on that. I believe, yes. Probably can't put my name on a copy of it. Because we'll figure that out.
There she is.
It's in the book. It is, let's take it.
She should be scared. What she did was despicable.
Okay, what else? I'm sorry. I think maybe, we had discussed maybe doing a schedule order. I know things have been moved around. Yeah, I had one prepared. About it because what's ready? The parties can come in and say, well, this is black, this is not, we're not ready to do this. Do we have everything back in?
No, we do not. What I would suggest, I think the next date we had was July. What I would suggest is we have 2 things. We have one piece of evidence is in the process of being analyzed and completed. We're expecting that shortly. Then we have another piece of evidence that's in the very beginning process of being analyzed. So we have those 2 outstanding things that we have to provide for discovery. Other than that, I think we've completed all the other discovery. We also have a couple other motions out there, one's regarding photographs. So we thought that maybe that we could take up those 2, anything that would come out of the result of results of the testing, these 2 pieces of evidence, and we need a motion regarding photographs in the period between now and July. Well, particularly, I don't know what Mr. Sproul's reaction will be when we get those 2 pieces of evidence analyzed results will be, but I think we probably should have a motion that between now and July as a status, or maybe to hear motions.
Dude, I think that's a good idea, but the motion, we both filed motions regarding some pictures. And I think that with a rather short amount of time, we could be prepared to argue that motion. And I don't think we need some way to do that.
We have selected photographs that we think would be contested. And we also will have an amended supplemental motion or response. And hopefully also by that time we'll have these results back from the lab. And so we can furnish those to Mr. Sproles, and he can determine what significance they have for his trial or his trial strategy.
And just, we do get the photos they provide us, so we have to have their money.
So as far as trying to get a schedule, I can't sit here and say, okay, the schedule's going to be finished on such and such day. We'll have motion without that because we don't have all of it.
First, I guess well, the other thing would be we keep the one in July, but when we get the results, we come to the court and ask, try to schedule a case, or maybe hear those motions prior to July, necessary. But we're letting the court know there are two pieces of evidence that need to be supplied, and that we know we're going to have a contested motion regarding photographs.
It's also going to be change the media.
Right. And we think that photograph, those, the court's ruling on that could affect what the court determines ultimately to do about having a trial here or somewhere else. I mean, the jury selected here or somewhere else. I think they might have some bearing on that.
June 24th, that one.
It's fun to stay.
What time did you say that? 1:30. That's fine.
So for the folks that are just joining, this is Megan Boswell. She's accused of killing her 15-month-old daughter, Evelyn Boswell. They are having a case here. I assumed it was the case to change venues. It appears that it's the case to separate charges for a second court case, so they're not compounded.
I've got serious concerns. How
I hope that clarifies for you, Jennifer.
this defense and that defense, the middle defense, they don't have all the evidence. And I don't even know what, have you been talking to the defense as far as what's still out?
Your Honor, what's buried, what's out there left, I don't think have any bearing on the mental evaluation. Defense regarding state of mind of mental health, you know.
Yeah, and this actually happened about 12 or 14 months prior to the disappearance of Summer Wells.
And the state has kept informed about the status of other like fault into that. I agree, I don't think that evidence will have there mental health issue. So you think you'll be prepared to
May even have been as long as 18 months prior to Summer Wells. I'm not quite sure. I have to look at the dates.
I mean, I certainly can pull all the slack out of it on mine, but we're dependent on your help and some other agencies.
Yes, I did. I'm home.
One of them would be help, but I'm not sure I can.
While the judge is getting information, please don't forget to share, like, and subscribe to this channel. And if you can go down to the bottom and put a thumbs up on this segment, I'd greatly appreciate it. It's free to say thank you. I'm unsure about that, Jackie.
Why don't we just wait and see what we have on the board? I don't see any reason for me to say, this, for us, obviously, you can say, okay, this is our schedule. Until we get all the evidence back.
Agreed.
We're spending all we have to get that.
I think you're right, Ron.
That's my.
I agree.
Have to put down a hundred schedule orders, if they still doing tests. That's all we have to wait.
We did.
There you go, Jennifer.
We could go ahead and move forward with the photograph. Motion regarding the photograph.
June 24th, we're going to deal with photographs. We may deal with mental health, mental. You all will keep me apprised.
Thank you, Ramsey.
Status that you got.
Yes, Your Honor. Yes. And we've asked for expediting processing of this, both these pieces of evidence. And TBI's agreed to do that.
All right, what else do you need?
I guess the time saves any motions.
Include,
We had filed the last one, we said,
This case is also in Sullivan County, one county over from Hawkins.
close the field. You can't very trial.
and that's what the motion says. So I think that would probably be an appropriate day to look at it.
Close trials.
Yes.
As we get through the photograph.
Thank you, Ramsey.
we may end up taking that. Okay.
Judge, one of our motions that we filed prior to the deadline is asking for permission to supplements to that change of motion. If you want to address it that day, I would suggest that I file all my supplements X number of days beforehand, so the state can vote them over.
Yeah. You need to have those filed 30 days before. If it's a substitute, All right.
So May 27th, I have all those filed.
Anything else today? So,
That's all, Your Honor.
anything else today? Commissioner?
No, Your Honor.
We'll take that 10 minute break.
Court can recess 10 minutes.
Perhaps I'm gonna double my life insurance knowing that you're with the TBI, because I'm afraid of my.
They are recessing for about 10 minutes, I believe, while the judge deliberates on what he's going to say. Many of you guys are watching this on their channel and already have the deliberations. I have backtracked it so everybody on this channel could see exactly what was happening in this case. So we're going to talk about this. I listened very intensely, and we will go back to this probably in the next day or so, and go back and listening to the detective that was on the stand that works for TBI in this case. The reason why that is so important is because we hear tidbits of the processes behind the scenes in investigation of child deaths, child disappearance, and things of that nature. We want to make sure that, let me just put this up until it comes back on. I'm going to go ahead and mute or unmute that so we can, as soon as it comes back on, I can hear it now. Hopefully it will, they plan on, let's see where we are. So it looks like they may not be coming back on, at least for right now, to tell us whether they are going to be separating those charges. This is not one of those that this is guilty or not guilty. This is a court hearing related. At first, I did think that they were discussing the change of venue in this. And then as we were listening, it was not about that. It was about separating the charges and having two separate court cases, one for the murder of this child and another case for the lying lying to law enforcement multiple times related to the investigation aspect of this case. They're trying to separate those charges. And as you know, knowing the legal process a little bit better than the normal person, there's such things as called stacking charges. So how the stacking of the charges work is that the more charges you have and you can stack, the lengthier your sentence is when they wouldn't normally be that lengthy if they were separated. So I think what the attorney here for Megan Boswell is trying to do is separate those cases to avoid that stacking of charges. Because even if they were tried together, she could be found guilty of one, but not the other in a normal court proceeding. So the reason for this, in my mind, I could be wrong, but the reason for this, in my mind, understanding the criminal process, is to avoid that stacking of charges and providing even a lengthier sentence than she would normally get if all those charges were separated. Now, what they're not trying to do is make each individual charge its separate trial, but they are trying to find this group and this group being two totally separate court cases, two totally separate charges. And I also want you guys to pay attention. We see like the Perry Masons and, all these different court cases on TV where you hear people raising their voice and being dramatic, like Law and Order and things of that nature. That's not what normal court proceedings look like. This is what normal court proceedings look like. Everybody, the defense attorney, the prosecutor, are typically very respectful of each other. They're very calm. They're very they show the court's respect in these settings, and that's what we got to experience today with this case. I won't be monitoring this. Megan Boswell is definitely just a horrible mother and deserves to be prosecuted to the fullest extent of the law. But what I'm looking for in this case, because this case, believe it or not, has not garnered the kind of attention that Summer Wells' case did. I don't know why, but it hasn't. But what I'm looking for in this case is any tidbit of information on the processes law enforcement's using, because those processes, it's the standard operating procedure. So what we're seeing here is if they're using this process in this case, guess what? They will be using that process in the Summer Wells case. And so knowledge is power, especially for people like me and you to understand what is going on behind the scenes. And this is a great look in to that crystal ball, so to speak, to see what's going on in the case and what has been transpiring, most likely in the Summer Wells case that we're not seeing, related to law enforcement, related to TBI. This is a great tool to use to get a little insight on, if you will, into the Summer Wells case, even though it's not directly related to the Summer Wells case. Now, again, many of you guys know the Summer Wells case is in Hawkins County, the adjoining county where Kingsport is. We've heard a lot about Kingsport, right? We've heard about the water hole. We heard about the hippie house. We heard about the Catch-22. That's all in Kingsport, which is Sullivan County. When we did our protest in front of Don Wells' job, right? That was in Sullivan County. So very close in conjunction wherever what happened to Summer happened. And I keep wondering, did they take notes from this case? Because this would have been, even though it's not a national case where people like me from Florida and around the country would have heard too much about this case, between Hawkins County and Sullivan County, I can guarantee people, when this case was breaking, were paying very close attention to it. So guys, with that, I want to tell each and every one of you, God bless you. Have a great and amazing day. If something is breaking or we're seeing something, I will be coming live. Many of you guys know I was supposed to be leaving to go to North Carolina. At the last minute, I was just looking at that 10.5-hour drive. And after making that horrific drive to the Panhandle, I just wasn't feeling it today. I really wasn't. I wasn't looking forward to the drive. I was kind of in a bum hug, baha, whatever. You know, I just didn't want to do it. So I called the sponsor. You know, I had, I was sponsored for this trip. I had the gas money. I had a place to stay, even though I was going to be camping out in my tent for a couple days. I did have a hotel room on Saturday, which I foregone just to be able to have some, to be able to stay here and rest, you know, between these segments and stuff like that, doing what I do. It was just too much for me this week. It really was. And many of you guys know I'm dealing with some medical issues and just not feeling up to par. So with that, guys, don't forget to like, share, and subscribe to this news channel, this channel, Bullhorn Betty channel here on YouTube. And I'm just going to go. I did a new intro, even though this is not the coffee club. I'm going to play my intro on the exit. So God bless each and every one of you. We will be back. If any more news is breaking, I will make sure we cover this to find out which way the judge did, you know, order, what he ordered, whether the order was granted or denied. We will be back. God bless you. Have a great day.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.